and faculty advisor to embark towards the journey of developing legal awareness among students and scholars, to organize various webinars as well as competition to push the legal mindset of scholars, to make them aware of their legal profounding. Founder Vivek Dikshit, co-founder Advocate Arvind Kumar, coordinator Dr. Anjana Singh, faculty advisor Advocate Sir Syed Anwar Alam. Now we are having four panels. In each panel, we are having four judges. First panel, we are having Kushagra sir and Ayushi ma'am. Second panel, we are having Rajdev sir and Vinay sir. For third panel, we are having Prashant sir and Kursh sir. For fourth panel, we are having Anjana ma'am and Adarsh sir. Now I would like to ask Ashruti to tell the rules of the debate.
Good afternoon, everyone. Myself Ashwati Patel here to tell the debate's rules and regulations. First rules are participants will speak for the motion or against the motion. The team Lawlicious will decide the stance. All participants will be given a unique participation code allotted by the team Lawlicious. Participants are requested to hide their identity during the competition. Each participant will have 5 minutes to speak. You will have 15 seconds at the end to sum up your arguments. If you want a rebuttal round, you need to inform the judges before the preliminary round. An indicator will be given after 5 minutes. Exceeding the 5-minute limit will lead to a deduction of points. So please adhere to the time limit. The participant's video must be turned on throughout the event. Reading from paper while debating can affect the result of the participants. Offensive, personal, and defamatory expressions will not be accepted under any circumstances. The event head may call to order any person using such expressions. Participants must have a proper internet connection, a web camera, and a working microphone for clarity. The participants are requested to join the meeting 10 minutes before the commencement of the competition. Participants are requested to enter the meeting using the following formats for their name, the team name, and the participant's name. Thank you. Everyone can, participants can take their time to from 2:15 we will start the competition. They must join with a proper internet connection and a web camera. Now everyone will join in their respective panels. The link will be sent in their respective panels. So please leave everyone. Thank you.
Child to start with is an individual who is still a child, immature, and lastly bound to make mistakes. In India, an adult is a person over 18 years, where 18 years is the age where a person can be considered for the things which he or she has done. In India, the age of the person are becoming the measuring unit of the crimes for crimes committed by crimes committed by two other persons. In India, age of the person considered rather than the brutality committed by them both. When we talk about the crime and justice act under juvenile, it is almost impossible to ignore the infamous case Nirbhaya case 2012, where there were 6 culprits, one of them being a minor at the time of the incident. We can witness the disability of the justice, where after the lots of struggle for order to be hanged till death, while the minor sentenced under Juvenile Justice Act for maximum sentence of only 3 years and sent to the rehabilitation home. After that, he was also given an amount of 10,000 rupees within swing machine for start his new life. How can our justice system can accord that types of person preferential treatment for the crime for which other person can be hanged till death or can be sentenced for the maximum punishment? Prevention is better than cure. If in Pune accident case, culprits parents do not make any kinds of mistakes, like they change the evidence and they try to help their child, and also the system court system justice juvenile act, they also help to save his life. If we do not act accordingly of their act, they will be more and more in future commits that types of crime. The system really thinks that murder and rape can be committed without culprit putting thought into it, without the maturity of the person. It can't be acceptable that this types of juvenile commits the crime. and get away with it easily. After the 3 year of imprisonment, can reform the culprit, and change the culprit in a normal citizen like we. It is unacceptable that the youth who commit such crimes are criminals. Their age should not matter or can get away from their punishment. If we do not act accordingly, there more and more individuals commit crimes. We can't speak out loud about that. For the heinous crimes like murder, rape, assault, kidnapping, and other like sexual offenses, mm, if they bestows cruelty upon innocent people and snatch their fundamental rights, they should be accountable. Same for the such as adults. We understand that the court trying to help the children because it considers that children cannot save their fundamental rights, cannot they are not able to save their fundamental rights. That's why the court system are helping them. In Juvenile Justice Act 2015, in which it considered that the age group of 16 to 18 will be treated as adult if they commit the heinous crimes. But this act is still not passed. Their punishment is not more than 3 years. Sir, bas, that's it.
Okay, Navya Mishra.
Can you imagine waking behind the closed walls and bars, seeing your inmate who is 45-year-old robber and you who are a 14-year-old had committed such a big mistake? Good afternoon to esteemed judges, Lawlicious team and all my dear friends. I am here speaking against the given topic. Should juvenile offenders be tried and sentenced as adults for serious crimes? From my point of view, they shall not be treated as adults because juveniles have a lack of maturity, they are not well and fully developed, and they do not have enough mens rea to commit crimes. Juveniles are less able to understand the consequences of their actions and that they must be given a chance to reform and change their ways. As we all know, adult criminal justice system, that is Indian courts, are not well equipped to provide education to young offenders. The juvenile justice system is designed to provide better environment and safety to juveniles, whereas adult criminal justice system is primarily focused on giving punishment. Consequences of trying juvenile as an adult must have a devastating impact on their future. A criminal record might limit the ease of job opportunities given to juveniles, and it will make it difficult for them to get reintegrated into the society. The main goal of juvenile justice system is to provide education and rehabilitation to young offenders. There are various provisions under Indian laws that are provided to ensure the protection of juveniles. The very first one is Article 39F Clause 10 of Constitution of India 1950 that stipulates that children must be given a chance to they must be given a chance and they must be insured against misuse and material relinquishment. Section 82 of Indian Penal Code 1860 and Section 20 of Bharatiya Nyaya Sanhita 2023 provides that nothing is an offence committed by a child. Section 27 of Criminal Procedure Code provides that any individual who at the date of appearing before the court is under 16 years of age must not be culpable with death or forever detainment. The Juvenile Justice Act was also passed in year 2000 to ensure the protection for juveniles. The principal target of the act was to guarantee that no person under 18 years shall be held up in prisons. There is a very famous case of Mukesh and other versus State for NCT Delhi, which is famously called Nirbhaya case and Delhi gang rape case. In this, there was a 23-year-old medical student who was returning from her from movie with her friend, she took a bus. There she was brutally assaulted and raped by six people. They threw her out after being raping, and she was naked when thrown out. She died in Singapore hospital while treatment. In this case, there were six accused who committed heinous and brutal crimes such as rape. They were given a death penalty by its Honorable Supreme Court, but the sixth member was a juvenile and he was sent to Juvenile Justice Board for rehabilitation. Since government has made such laws for the protection and safety of juveniles, so trying juveniles as adults must have a negative impact on their life because they have a greater chance of rehabilitation if they are tried through juvenile justice courts. They literally lack the neurology to know better, and the age till 18 years is of juvenile and they are prone to make mistakes. Hence, they must not be tried as adults. Thank you.
Navya, please tell us something. Uh, what do you think the offender age under the Nirbhaya was juvenile? What was his age at the time of committing of the offense?
Sir, he was near to 18 years.
Okay. So now tell me, you in your sentence self stated that the girl was thrown out of the bus naked.
Yes, sir.
Now tell me this thing, is it not enough to treat a person under the not under juvenile justice who has uh, proper understanding that what he is committing is an offense, is a heinous offense. Why should he not be treated as an adult?
Sir, government has made such laws like Juvenile Act was passed in 2000 and the Juvenile Act was considered in 2015, which tell us that 16 to 18 years must be treated as an adult. But that act is not still passed.
Here, here I'm talking about your opinion
Yes, sir.
whether that person should he be treated as an adult or not.
Sir, he should not be treated because at
Why?
the time of punishment he was not a adult. He was a
I am
juvenile.
here here the it is not about the age. I'm talking about the intention, the offense which is he committing. If a
So
person
maybe he was.
as we all know that for committing an offense, men's is very important.
Yes, sir. But maybe he was
So
pressurized by five of members who were there in the rape case. There must be
did
many
you
consequences.
have you read his judgment of the FIR?
No, sir, I have read just the judgment of Supreme Court. It has given death penalty to six of them. But sixth member was juvenile and he was sent to correctional home.
Okay, okay, Navya.
Thank you, sir.
Both of the participant, anyone here is gonna take a rebuttal.
No, sir.
Rajesh, if you have any questions, sir, you can ask.
Yes. I have a question from Siddhi Sharma.
क्या सर?
I have a
Shidi, please
question.
open your camera.
Siddhi, are you listening?
Yes, sir.
Siddhi, I have a simple factual question. When you were researching about the Juvenile Justice Act, right? You
Yes, sir.
went through the Juvenile Justice Act 2015 also and its latest amendment. Along with that, you
Yes, sir.
also read about the theoretical things of the juvenile justice. Can you remember any two landmark cases of juvenile justice?
Yes, sir. Sakti Mills gang rape case in which there was seven individuals. Two of them was a minor. And same as
Okay.
Nirbhaya case, this is also the juvenile related act.
All right. Okay, Siddhi. I have one question from Navya Mishra. Okay, Siddhi.
Yes, sir.
Uh, do you remember any latest amendment in the Juvenile Justice Act?
Sir, I think it was of 2015 only.
Is there any amendment which took place in the last 2 3 years?
No, sir.
Okay. Okay, Siddhi and Navya, do you have any questions for each other for the purpose of rebuttal round?
No, sir.
All right.
Nazmi at the next slot now.
Today I am going to speak in the favor of the notion that juvenile justice crime should be treated as same as the adult's crime. So first of all, I would like to inform everyone that juvenile justice crime
Vidushi,
are
turn
the
on the
crime.
camera. Vidushi, turn on your camera, please.
Sorry, sir. Yes, sir. Good afternoon. So, first of all, I would like to inform everyone that juvenile justice or the juvenile crimes are those crimes which are done by the children who are less than 18 years old. But, sir, if we see in the today's society that the most heinous crimes are somehow done by the children who are going to become the next youth. As we see, so many times in our history, from around the 1990 case 1990s till now, we have seen many children who has changed the definition that the children are now that children are the incarnations of God. So in 2012, there was one case which is known as the Nirbhaya case. So in this, a 16-year-old child has done such a heinous thing to an anyone, which changed the history and the definition of everyone, which defined us that children are also capable of doing the most heinous things in our society. Not only that, sir, but if we see in our recent Porsche case, then it was a 16 or 17-year-old boy who was drunk and was responsible for killing two engineers who were innocent and were going to do so many achievable things. So for sir, as a law student, let us imagine, as I sometimes imagine, that if any loved one was at the place of those people who are the victim of these juvenile crimes, then what would happen? So not only because, sir, if we see that our loved ones are and sir, if one yes, and hold so many values to us, but sir, for some people, because of their um, mental sickness, or I don't know what to call it, because of them we lose them. Sir, in there is one case in Japan which is also known as 49 days case, which is all it popularly, and in reality it is known as the murder case of Juneko Fureta. I yes, sir. So in this case, there was one girl who was Juniko. She was a school going girl. She was very brilliant, popular, kind, and all. But sir, she was brutally raped by four children just because she rejected one boy of her class who was in the not so good activities. If we say were in were a member of a syndicate or a gang type, sir, and for 49 days she was brutally raped, tortured. Her skin was burned and not her bones were broken and many things. Sir, and all these things were done by 16 or 17-year-old children. Sir, if the thing is if that level of heinous things are done by a 16 or 17-year old children, then I do really have the question from the judiciary that are you sure that the children are still innocent, that they have the eligibility to get reformed in the future? Because if they can destroy the life of someone, not only one person but the whole family of that person, just by taking their loved one away from there in such brutal way, can then evoke the guilty in them, the guilt in them that they have done such a wrong thing. And sir, in and after this crime, sir, this which happened in around 1980s, to be exact 1988, sir, the Japan government changed the juvenile crime cases age to from 16 to 14. So then, if we see in our Indian society where we treat children as the incarnations of God, we say that children are the most innocent beings. So not only that, but our Indian society teaches us that females are the goddesses, and not only that, sir, but we also teach our male boys children that we should always give respect to females. So there they do such heinous level of crimes that are popularly known as the Nirbhaya case. So do Nirbhaya case are one of the mill case. I don't remember the name. Sorry, which happened in 2013, and one of the Ryan International School murder case in which a 7-year-old boy was killed by a 17-year-old boy. So this kind of mental sickness cannot be treated, and that is why I want the every children to know that when you do something wrong, you should be held responsible for what you are doing wrong. It does not matter what your age is, whether you are a 7-year-old child or whether you are 17-year-old. When you are wrong, you should be, unless you had no intention of doing that, it happened unintentionally, then it's all right. Otherwise, I do think so that every person should be held, just because our judicial system believes in reforms, then it is not going to work. So then it is not going to make our society more peaceful and safe for anyone. Because sir, if a child is who is just 7-year old is not safe, and 23-year-old college intern is not safe, then I do really have the question that are we safe? Because if the children are doing those things which are known as to be innocent, then are adults going to leave us, or are adults going to make sure that we are not going to get hurt, or don't, or okay. So at last, I would like to conclude that just because of some children or some sick people, we are going to face a lot of problems in future as well. So I want the judiciary to take strict action and treat juvenile justice cases as same as adult crime cases. Thank you.
Ritushi, you said that we should have strict laws for the um, children who are committing these offenses. But what about the reformative theory we are believing in, or the Mahatma Gandhi told about the reformative theory? Will it be not against them?
Sir, I do believe that reform theory now is not going to work. Sir, it was when Mahatma Gandhi told this theory, it was around 1950s, sir. It was so peaceful. I guess it was peaceful then now it is. And maybe it was more safe than today's world. Sir, and if we see that sir, after a few years only, in one BMW case also happened, which was also done by a 17-year-old boy, and that to be exact, in Pune, Mumbai or Pune, which happened in the 88, sir. And do you really think that after only 41 years old, when our India got independence today, sir, we are eligible to say that the reform theory is going to work? Yes, our Indian history is the best example of saying that reform is the best way. But, sir, sometimes people are having the sick mentality that can take away someone's life so peacefully, and they will not have any type of guilt. The only thing I believe in criminal psychology, that they are only afraid of two things: that what will people say when they get to know about this crime, and what punishment they are going to get. They do not give it a speck of any thought that yes, we have done a heinous crime. Sir, even if we say the bandit who used to kill the people and used to wear a necklace made up of the thumbs of his victims got changed, but sir, even after that also he got his punishment. I clearly don't remember, sir, by the public only or by the king himself, but he got punished. He got to know that karma is real, sir. Our Indian history also give us the reason that even though we believe in reformation, but we do not make sure that you are going to repent, sir. In our ancient history, that we have one prashchit, sir. There we have to repent for our mistakes, sir. In juvenile jails, as per my knowledge, they are only just taught that it is wrong, it is right, sir. As a 16-year-old child, I was also knowing that killing someone or torturing someone, blackmailing someone, etc., are illegal, sir. They are punishable, sir. Then how come they have the problem? Because, sir, we have do not have that strict laws, because the day we will have those strict laws and we will start implementing it, not only our society but the whole nation will start to uh, applause the judiciary after a few months, because we will take time. Because yes, we have some sentimental values that they are children, they have the whole life in front of them, but sir, what about the people who has suffered because of them? My question is, sir, that only. Because if we see that,
Okay, Trish. Okay, Vidusha. Okay.
सर वो आ रहे हैं बस जस्ट 2 minutes.
Okay, Ram. You can begin. Okay, sir. Good morning, everyone. My name is Ram Singh Rathore, and I'm doing BLLB first year. And my topic for today is: should juvenile defenders be tried and sentenced as adults for serious crime, for which I'm speaking for the motion. Old enough to do the crime, old enough to do the time. These words resonate deeply, especially when discussing the contentious issue of whether juvenile offenders should be tried and sentenced as adults for serious crime. While this issue's moral and legal complexities are vast, the principle remains clear. Serious crime deserves serious consequences, irrespective of the offender's age. A juvenile, by definition, is an individual who is still considered a child, immature, young, and prone to errors of judgment. Legally in India, an adult is a person over the age of 18. Their age threshold is a legal marker of when an individual is deemed capable of taking full responsibility for their actions. However, the disparity in how the law treats individuals based solely on their age rather than the severity of their actions raises critical concern. A crime committed by a minor is often dismissed as a mere mistake because of the offender's age, while the same act committed by an adult is met with harshest penalty. As Justice Kennedy stated, I quote, "The law must recognize that some juveniles are so mature that their crimes so heinous that they are deserving of the adult penalties." The Juvenile Justice Care and Protection Act 2015 represents a step in the right direction by allowing juveniles in this age group to be tried as adults for heinous crimes.
Soon after the 2012 Nirbhaya gang rape and murder case began, one of the taking points was the juvenile status of a person accused of committing a serious crime. Among the six accused, one was a juvenile. The cause for trying him as an adult was a factor in the 2015 amendment. A year after the incident, her parents moved to the Supreme Court challenging the juvenile justice board trial for the 17-year-old accused. They wanted him to be tried for Czech criminal court. They weren't happy with him instantly getting away with murder. A 2017 report outlined what that person is up to now. He's a cook, has changed his name, and supposedly turned over a new leaf. The bench of Justice Subodh Abhyankar, hearing a case in Madhya Pradesh of a 15-year-old raping a minor, said that the legislature hadn't learned its lesson from the Nirbhaya's case. It gave freedom to delinquents under the age of 16 to commit heinous crimes. The Nirbhaya case isn't the only one. The Shakti Mills gang rape case, Mumbai 2013, Gurugram school murders case 2017, Unnao rape case 2019, Shivani Bhatnagar murder case 2019. While the offenders were sentenced to death under the rarest of rarer doctrine, the juvenile was sentenced to just 3 years in a correctional facility. How is this dealt with in other countries? In Germany, for example, the children between the ages of 14 and 18 are tried in a youth court, irrespective of the crime. They cannot be imprisoned for more than 10 years and less than 6 months. In the United States of America, the trend has been towards trying juveniles as adults in cases involving violent crimes. This approach ensures that the gravity of the offense is matched by the seriousness of the punishment, reinforcing the principle that justice must be served. The role of the legal system is not just to rehabilitate, but to deliver justice, both to the victims and to the society at large. The juvenile system must send a clear message that age does not absolve one of responsibility for serious crime. Justice Deepak Mishra, former Chief Justice of India, stated, I quote, "The crime is the result of a psychological preserved mind. Such crime reflect the brutality of the mind and not of the body. Age cannot be a shield when the crime committed has the intensity of an adult criminal." I unquote. The legal framework must balance the need for rehabilitation with the imperative of ensuring justice and public safety, holding juvenile offenders fully accountable for their actions when their crime warrants it. That's all I have to say. Thank you.
Ram, please open your camera.
रामवर्धन सिंह, आप अपना कैमरा ओपन करिए अगर बताया जा रहा है आपसे तो।
Yes, sir. एक minute.
Hmm.
Yes, sir.
Ram, now tell me this thing that you were saying that a person should be treated as an adult for the heinous offenses. Now, if a child who is a 16-year-old child and he is a first-time offender, so so will it not be injustice for within that he's been treated as an adult with those criminal who are not habitual offenders?
Yes,
What
sir.
are your opinion on this point?
So that even the first, if he is a first offender, he should be held accountable for his mistake. Like if he is just excused and sent to a rehabilitation center, he may be turned over a new leaf, but in the back of his mind, it may be somewhere he that he can just do a same crime again, and he will be dealt in the same manner.
No, in the
So
back of his mind, you're saying there's also a chance that he'll be, if he go to a child care home center, he can get reformed. I mean, in the criminal law, we see that we say that no accused should be held guilty even if hundred of criminals are being left. So will it not be injustice with him if if he's a first time offender and we'll treating him as the same criminal as the adult criminal?
No, sir. If he is like, if a crime is like major, then he should be dealt the same manner as an adult. Like even
So
as a,
what
if
about
he's
the
a first
reformative
offender.
theory that Mahatma Gandhi has said?
I don't believe in that. Like in this age, a 16 years of is fully mature to understand what the serious crime is, what not. Like if he
Oh,
can,
Radhe, so you having questions?
Yes. Okay, Ramvardhan, you talked about the maturity, right?
yes, sir.
So, how can you justify the Nirbhaya rape case minor who was just 6 months less than 18-year-old? Do you think that just after crossing 18 years, he suddenly got the maturity and understanding of all these things?
Maybe he would have.
All right. So, you know the name of that person who was minor at that time? That minor person name?
No, sir, I don't.
Okay, he was tried in Juvenile Justice Act or adult, as an adult.
Uh, he was first he was tried as a juvenile justice act.
Okay.
Then
Okay, he is roaming free in the society right now. Okay, he was set free.
yes, yes, sir.
Don't you think he can commit the same crime again?
So he definitely can.
All right.
Okay, Ram, you can now leave the meeting.
Okay, thank you, sir.
Is this slot number 4? Ava and Mehak, right? Slot number 4.
Mac, kindly unmute yourself.
All right, Ava, you can start.
Okay. Ma'am, I would like to start my speech with the very beautiful line said by Mahatma Gandhi that if you want the real peace in the world, please start with the childrens. This line exactly says that we should that how the nation's development depends on the children. According to Mahatma Gandhi, the growth of any nation depends on the children as they are the future of our nation. Our constitution provisional supports that, like Article 15 clause 3 supports that state can make special laws for women and children protection, and like Article 39 clause F says the children should get equal opportunities and facilities for their development. But what if what if the children's and the minors are involved in heinous crimes? But that should be a case that it really reflects the development of the nation. That I would like to give a strength to my statement that the juveniles are really involved in the heinous crime by discussing some of the case laws. For example, the Nirbhaya case rape, in which a boy who was just few months less than the age of 18 was involved in a very heinous crime like rape, but he was not convicted. He was just sent to the correctional house, and after that he was released. So, but the other four were convicted as they were adults. So, I would like to discuss that for these types of heinous crimes, sometimes juvenile protection does not work right. And the very famous case, which is a very recent case, which has guarded the attention of the whole nation, and especially the juvenile members. Protection members, that the case was Pune Porsche car accident, in which two two IT professionals had been dead because of the 17-year minor was driving the car in a very high speed, and he was intoxicated too. In these type of cases, the general provision which really works is IPC section 300 IPC section 304, which says that the maximum punishment is a lifetime imprisonment, or the minimum punishment should be 10 years of imprisonment. But he was not punished with the same, and his act was as equivalent to the adult. It was not negligently done. It was all intentional because he was intoxicated also. The two people were dead. They were they were IIT professionals. They would have served good to the nation. And sir, I would like to share some of the data which was given by the National Crime Bureau Board Commission, that about 36,138 cases in which juveniles are registered, and in those cases there are 1,733 cases which are about kidnapping, and there are 1,633 cases which are about rape, and there are 844 cases which are about murder, and there are 806 cases which are about attempt to murder, and there are about 1,392 cases in which the women are mortgaged out of her modesty. So, by these facts, I want to really discuss that sometimes the juvenile protection does not work. They should be treated as an adult in the cases like such when they are involved in a really heinous crime. uh, and sir, I would like to conclude myself by saying that in the judgments like Pune wala Porsche car, in which he was not convicted like a general citizen under IPC, and in the Nirbhaya rape case, in which he was the most active member of that case, but he was still not convicted for that same offense, and the other four were convicted. But according to that, the people who are the juveniles who are really involved in those cases with a very heinous intention, they should be treated as an adult on the basis of cases, on the basis of facts of the cases, and on the basis of the relevant evidences. Sir, I would like to really share share that the juveniles who were registered in those cases which are released by so I would like to conclude that from the data which is collected by the National Crime Bureau, and the case laws like Nirbhaya rape case, and the Porsche car accident, we can see that the juveniles should also be treated as an adult during the proceeding, and same with the judgments and the statements given to them. Thank you, sir.
Okay, Abha, I have a
Respected judges, esteemed opponents, and dear audience, today we gather to discuss on a topic that is very hard, that is at a strike of the heart of the justice and the future of the society. Should juvenile offenders be punished and sentenced as adults for the serious offenses? I hereby stand before you to argue against this proposition, as adults, as treating juveniles as adults and sentencing them on the as the same. It not only undermines the principle of justice, but it also undermines the principle of fairness and disregards the potential of rehabilitation and growth that is very inclusive in every young person. Mentioning a quote of Nelson Mandela, as the same of Mahatma Gandhi says, there can be no keener revelation of a society's soul than the way in which it treats its children, which simply says that treating the children or the juveniles of a country is the foremost thing a nation must follow. Who are juveniles basically? Those who are under the age of 18 as per the age criteria. And when we come to offenses, those who comes under the petty offenses, serious offenses, and heinous offense category. The heinous offense category in which the age is altered from 18 to 16 years, correcting. Next, now here I'll be demonstrating that why trying and sentencing the why trying and sentencing the juveniles as per the adults laws and regulation is not right, as it is morally as well as legally wrong, and it also counterpart and it also is counterproductive to the broader pursuit of justice. The point number one is development differences between the adults and the juveniles. The study of the National Institute of Medical Health says that found in its research of neuroscience that the juveniles' brains are not fully developed as the adults' minds are, and similarly mentioning a famous US case of Rober versus Simons, in which the US court, US Supreme Court mentions that it is unconstitutional to try a juvenile as same as an adult because of the differences in the capability of their minds. The next point is the potential of rehabilitation. We all know that there is higher possibility of rehabilitation among the young and among the juveniles who are the youth and who are the future generation. uh, Even when we sentence them on the grounds as the adults, it will only hamper and impact their future opportunities. It will have negative impacts on them. And mentioning the most famous Nirbhaya case, as mentioned, as my opponent said, even in that case, the feature of the rehabilitation was reflected because the juvenile, was sentenced as only per the earlier mentioned rule. The age was the age was altered, though no matter what's the no matter whether the age was earlier what or not. Even in the voting rights, the age is still 18 years. And if the person are too understandable, the society too understands the same, why the voting age is not degraded, not going far from the topic. The next is Salil Bali versus Union of India. In the same case, it was also mentioned that the Juvenile Justice Act also stated the same, that the juvenile should not be treated as per the adult rule. Further, there are evidences of ineffectiveness of the adult sentences on the juveniles. It is clear that there is high recidivism among the juveniles. They are more prone to reoffend when if they are sent to the adults prisons. And it is clearly stated by the United States justice system. There are many examples of the person in the juveniles that who later did some great works, such as James Anderson. I would like to mention his name, that how greatly he had come up after being in a juvenile session. Further, there is Sarah Sergan from the United States, who has been a famous writer, motivator, author, Shaka Sanger. Yes. Yes, thank you. The system, it is only to suggest that the adult sentencing should not be given to the juveniles, and because it does not achieve its intended goal of deterrence and public safety, but rather it contributes to the cycle of criminal working. I would like to further mention that by maintaining a separate juvenile system, we uphold the principle of justice, fairness, and also account to unique circumstances among the youth offenders. Thank you.
Now I have question for team code 16.
Yes, sir.
Um, as you can see that the crime rate of the juvenile is increasing day by day.
Yes, sir.
So and and also the seriousness of crime that they are committing is the same as that of the adult. So why not the age? Why not he should be treated as an adult offender?
So here, the thing that is mentioned, you are mentioning about the deterrence. When we say that the juveniles are committing more crimes, there is no such data which can clearly mention that. There is no such data which can clearly state that by sentencing the juveniles as adult will deter the further crimes. Only it will affect the juveniles who have committed those crimes and their future opportunities. As I have already mentioned the name of some eminent
I'll
personalities.
I'll I'll give you the data. Study of crime rate in India from past decade. It shows that the percentage of juvenile justice crime as compared to the crime has increased by 0.7%. ये 10 साल का डेटा है आपके पास.
Sir,
And
uh,
uh,
um, sir, I'm
and
mentioning the data which says that there is no data specifying that by sentencing the juveniles as per
no,
the adult.
it is not the data that you're mentioning. See,
Yes,
giving of sentence, we are not here for the deterrent theory, we are here for the reformative theory. But in the same, if we're not punishing the offender, what justice we are giving to the victim? The point
sir.
here is this.
Okay, sir, I got your point, sir. Sir, mentioning to provide justice to the victim or towards the society during the heinous crimes the juvenile offenders had committed, I would only like to mention that by when we provide harsh punishments to the juvenile offenders, it will not fulfill the principle of rehabilitation. The main purpose is to improve the understanding, and when we consider the severity of the crimes, we should also consider that there is no that there is difference in the development of their brains. They do not have the cognitive ability to understand the severity of those crimes. So how can we punish them for for incapability of such
So
understanding?
you are saying that they don't have this cognitive ability. So
Yes,
when
sir.
a juvenile is committing a rape, don't you
Yes, sir.
think he has the ability to understand what he is doing with a sexual offense or not? And are you saying that the offense committed by a habitual juvenile is not with his proper intention or cognitive intention?
So once a heinous crime is committed, the juvenile will came on out of the juvenile center only after attaining the age of maturity. And if again the crime is committed, then the crime will be committed by a major person, not a minor one. And next, if such crime is committed by a person, so I'm not saying that it depends on the age also. If we are mentioning the age of 16 years, it is still a age that is mentioned by the amendment in the justice act in the year 2015, where it has altered the age from the 18 to 16 years, and not mentioning that they are not able to understand the severity of crimes, but still they are incapable of the same. And it is clearly mentioned by the report of the of the National Institute of Medical Health, and in the famous case of the U.S. Supreme Court, where it says the same that they are it is unconstitutional.
Okay, okay. Now,
So,
Abha,
Yes, sir.
uh, now you tell me that you were for the motion. You are speaking for the motion that they should adult he should be treated as adult for the serious crimes. What
Sir,
if
can you please repeat the question once?
I am saying that you have mentioned that a juvenile offender should be treated as an adult for a serious crimes. Okay?
Yes, sir.
Huh. Now tell me one thing, that if an offense is committed by a person for the first time,
Yes, sir.
and if we commit that person uh, as an adult, he'll be living in prison with the other criminals who are and habitual offenders who have been uh, offend who have been criminally liable in many cases. So matlab, is it not affecting the right to equality or something? Uh, they should be treated as a different perspective.
Sir, according to the data which I have given in my which I have stated in my statement, sir, we can see the number of increasing crime rate by the juveniles. Uh,
Okay.
and sir, in such cases like Nirbhaya rape case and Pune wala Porsche car case, the offenders were very really close to 18 years of age, and they had did a very heinous crime, and they should be treated like an adult in the proceedings and as well as in the judgments too. So for example, so like I've stated about the National Crime Bureau report that like there are 844 cases of murder in which juveniles were there, and there are 806 cases in which uh, there was attempt to murder, and like they are increasing in number day by day. So the if by seeing the heinousness of crime, if there is a punishment in any case or in a number of cases, it would set a status, or it would set like a level to juveniles, that they can be also treated as an adult in a proceeding. So it will create a little bit changes in the little bit changes in the data. Maybe the juveniles will decrease the number of the cases, or they will not commit any crime, like, or they will develop the things like they will be treated as an adult if they commit any crime like that.
But once a juvenile has been treated as an adult, he is kept in jail with the other inmates who are very senior to them. They have committed all the murders and all, and we see that the different activities. We're not giving him a chance to it is said that every saint has a past and every criminal has a future.
Yes, sir.
We say this statement, and we why should not we give him a chance to be kept in the uh, child care home, and let him give him a chance. And as it has been mentioned by the other speakers, that once they are kept in this child care home, they are they are being out after they have attained 18 years of age. So why should we not give them a chance and make them suffer with the other inmates?
Sir, on this, I would like to say that if the crime that I said that they should be treated like as an adult. That I did not say that they must be treated. If the crime is too heinous, or the as per the evidences and as per the case facts, they should be treated like an adult, and we can make amendments also in the case laws, that in the Juvenile Care Protection Act, that if there should be a they should not be kept with those prisoners who are really have done so many heinous crimes. They can be kept separately, but they should be punished as if they have committed a really heinous crime.
Okay, Abha.
Because
Rajesh sir,
I
we
really
can.
agree.
Okay, Abha. Okay, I got your point. Rajdev sir, you have any questions?
Yes, sir. Mac, I have a question for you.
Yes, sir.
I want to know your stance on the view that a heinous crime is done by a 15-year-old and a 17-and-a-half-year-old. Do you think that the gravity and the understanding of both the children is same, and do you still justify that they should not be treated as an adult?
So, as you mentioned that there is a gap of a 1.5 year. So, when you are talking about a gap of such 1.5 year time period, which is approx 2 years time period. So when we are talking about a person who is of 15 years and who is of 17 years, and mm, and they both have committed the heinous crimes whose punishment is more than 7 years. So as per the alteration in the act, the one who is below the age of 16 year, he should not be, uh, as per the law, he should not be tried as uh, as an adult in those cases. But we are on serious offenses, as the one who has as the one who has gained the age above 16 years, he is considered, he will be basically he will be convicted as an for the offense as an adult. So here I'm mentioning that they both literal they both, from my perspective, don't have such ability to understand, especially the one who is of 15 years. He don't have the ability to understand the severity of the offense he had committed. And for once, if they had committed the offense, they should provided a chance, so that they can have a better scope in their life.
All right. Okay, Abha Shukla, I have a simple and factual question for you. You talked about the NCRB report, right? Its
Yes,
data.
sir.
So can you just brief me about what is NCRB and under which ministry it works?
Sir, NCRB is uh, matlab it provides a data about the crime, about the increasing of the crime, and it provides how the crime rate is increasing or decreasing in number, or how the crime is increasing as per the perspective of the women. For example, in 2023, the National Crime Bureau report has provided that the crime rate in Maharashtra and Delhi against the women has increased in more number.
Okay, can you tell me the ministry under which it works?
So, manage.
All right, no worries. Thank you.
Ma'am, should I start first? So, to my esteemed opponent, when you are talking about the severity of crime, that you are demanding that the juvenile should be treated or they should be convicted as the adults, why are you not focusing that they lack the development stage and they do not have they do not have such mental capacity? And even when you are acknowledging that the crimes of the juveniles, why are you not focusing that they also have the higher potential for change and reintegration in the society? Also, as I mentioned, mentioned further, that there are people who are in the juvenile center, such as Shakha Sengar, who has also written a book, a best selling book, Writing My Wrongs of My Life, a type. And also, when we are talking about deterrence, that they it would set a standard for other juveniles, that they will other juveniles, that they will not commit such crimes. So researches does not show that trying juveniles as adults does effectively deter the crime. In fact, juveniles are less likely to consider the long term consequences of their actions, and suggesting that adult sentence and suggesting the adult sentencing to the juveniles does not prevent future crimes, but rather it only exaggerates the problems of the society, as it works as a criminal cycle, as a working of the criminal cycle. The moral and ethical responsibility is not only on the juveniles, it's also depend on the society as well, that they should understand that the juveniles who has committed the offenses, they are not of such mental capability, and addressing the violent juvenile crime rates, in which the perception that juvenile crime rates are rising and the harsher penalties are needed, it is not supported by evidences. Yes, that's all. And protection of society from dangerous individuals is clearly important, but trying juveniles as adults often, it also it also leads to counterproductive, it is counterproductive to the goals. And not mentioning the data that what the juveniles have committed, the crimes they have committed, is there any data that after being mm, I'm sorry, correction, that the juveniles have committed such crimes. It also, there should be data that the juveniles have also got the opportunity for their better future if they are tried as per the Juveniles Act. And all the cases you have mentioned, in which in those cases the juveniles were not tried and convicted as an adult. Instead, uh, the cases had just the cases had just set up standard or bar. Thank you.
Okay, so on this, I would like to say कि it is not always that every person who had sent it to the correction home will be good after, or he may not commit the crime after. But if he is not, but if he is not punished for that heinous crime, it may uplift his willingness to commit more crime. It may be like he may will be addicted, or he may get the habit of committing those crimes in further as his age. If he is not if he is not convicted, or if he is not convicted in a proceedings like adult, because because every juvenile never gets never gets corrected after going to the correction home. And even if in
This is what the rehabilitation centers do. The rehabilitation centers are made for correcting them. They are not for doing. They are. This is certainly the work of the rehabilitation centers. They are for this purpose only, that they have to uh, rehab the juveniles, and further to provide them proper um, proper understanding that how severe was their crime. Not mentioning that they should not be punished, but they should be punished as a juvenile, not as an adult. There should be punishment for a juvenile. Once if It also depends on the severity of the crime, as you mentioned, but severity of crime also comes with the mental development stages.
yes, of course the mental development really important. But what if he gets in his mind, for example, that Pune Porsche car accident, that he knows that he was very well intoxicated, he was in a rush driving, but even after the Bombay High Court gave him a bail. So it was a very easy bail, and according to IPC section 304, he would have been convicted if he was above the age of 18. He would have been got the punishment of lifetime imprisonment or the imprisonment of 10 years. So what about in those such cases, in which the person has acted like an adult? If he has acted like an adult, and he knows if he may commit a crime, and if he had known that he may go through another crime, so this will really uplift the juveniles that they may commit after afterwards more. We can make like amendments in juvenile care protection, that they should not be treated like those prisoners who have committed so many crimes. And those crimes, if they are kept with those prisoners who are really heinous and grievous in nature, it will definitely reflect their mental capacity. But in case they are not even punished, so in that cases it may increase their mental capacity to do more crimes. So I would like to say कि, there should be at least some punishment for that.
There is punishment for them by taking them to the juvenile center. Why are you saying that they should be punished as adults for those crimes? If they are punished as adults,
If,
it would increase their recidivism power, which basically means that their further tendency to do the same crime. So even the United States justice system says the same. If they are tried and convicted as per the adults rules and regulations, their tendency to do the crime increases. Instead, when they are kept to the rehabilitation center or the care or protection houses, their such tendency degrades, and they got a better life for future opportunities. Don't you think so? Providing them one chance is.
it is definitely well said that they should be provided opportunities, and even our constitution, so many articles which I've discussed in my speech, that they really help the children of our nation to for their upliftment, for their opportunity, for their education system. But
If you are
what
arguing the same point, then why are you arguing that?
what
Okay, we'll stop this discussion there. It is all.
Yes, sir.
Now you can both leave.
Thank you, sir. Thank you,
Thank you,
Abha.
thank you, sir.